In 2020, amid the Black Lives Matter movement, there were widespread calls to remove monuments associated with the Confederacy. Although these calls were heard in the Confederacy's former capital, Richmond, Virginia, removing these monuments wasn't a seamless process. In Taylor v. Northam, we'll explore whether restrictive covenants in a deed that was over 100 years old can restrict government speech today, even in light of changing public sentiments. In 1887, the Lee Monument Association was conveyed land to build a statue of Confederate General Robert E. Lee in what's now Richmond, Virginia. After completing the monument, the association decided to donate the property and monument to the state. In 1889, the Virginia General Assembly passed a joint resolution authorizing the governor, who was also the association's president, to accept the gift and guarantee that the state would keep the monument on the land in perpetuity. The governor signed the deed the following year. In 2020, civil rights demonstrations and negative sentiment toward Confederate monuments prompted then-Governor Ralph Northam to approve a plan to remove the monument. Helen Taylor and others who owned property in the area surrounding the monument and depicted in the 1890 deed sued Northam in the Richmond Circuit Court. Taylor argued that the deed contained a restrictive covenant that prevented the monument's removal. Northam argued that as the current governor, he had the authority to remove the monument. In addition, the deed's language didn't create an enforceable contract right, and even if it did, the restrictive covenant would be unenforceable as against public policy. Before the suit could be resolved, the Virginia legislature passed an amendment repealing the joint resolution and ordered the monument's removal. At trial, Northam introduced the amendment, as well as expert testimony, to demonstrate the negative public sentiment concerning the monument. Finding that the deed contained restrictive covenants that were unenforceable, the Circuit Court held for Northam. Taylor appealed to the Virginia Supreme Court.